So I'm going to spend a bit of time talking about different types of ADR mechanisms, why you might choose one over another, what are the pros and cons of some of them. But generally speaking, some of the reasons why parties may choose ADR are listed on the slide there. So generally speaking, it would be cheaper to go down ADR versus court. There is the opportunity to have subject matter experts act as decision makers, and we'll talk about how some of that might play out in arbitration cases. You might have restrictions under the contract or sporting body rules. So, for example, FIFA have a rule within their statutes that say all football disputes have to be kept out of court and need to be resolved by arbitration. So for that reason, some of the football governing bodies will have rules within their regulatory regime which say that parties cannot take disputes to court and instead have to resolve matters by arbitration. So mediation is a process where parties will meet with an impartial, neutral person chosen by both parties who will assist them in a facilitated negotiation to resolve their disputes. Now, mediation is also very common in resolving sports disputes, and I've been involved in a number of sports-related mediations, typically involving employment disputes. So, for example, a manager leaving a football club, there's a dispute over a termination payment. Ultimately, there was a dispute about a sum of money that needs to be paid. And in those sorts of situations where there will be an element of negotiation, perhaps parties' positions become a little bit entrenched. A mediator can help to break the logjam. And so any issues of a pure economic nature do lend itself to a mediation. And there's a wide array of disputes which may be eminently suitable to be resolved by mediation. The other side of that is what I have heard happening in the past is actually parties arbitrate in the morning. So the individual sits as an arbitrator in the morning, makes a decision, puts it in an envelope on the table, and then says to parties, right, let's mediate in the afternoon. If we can get a deal, great. The envelope never gets opened. But if not, at the end of it, if the mediation fails, the arbitration decision is final. And the pressure of that decision being on the table, I imagine, would help facilitate a deal being done at mediation. So not very common at all. Either med or adjudication, but just for completeness, I did want to mention them because in theory they are methods that could be used to resolve sports-related disputes.